Okay, terrific. So thank you, and appreciate everybody's patience for just a couple of minutes there. It's my pleasure to introduce you to Mike Best. Mike is the Chief Operating Officer of Bloomberg's Industry Verticals and is the co-host of Bloomberg Law on the radio. So please, thank you for joining us, Mike, and I'll let you introduce your panel.
Well, yeah, I'm the least important person up here right now, so let me introduce our panelists. Everybody can hear me, I hope? Okay, the mics are working, good. So to my left, and we'll go across, Elizabeth Baker, who has insisted to me that we must call her Boo because that's her name, is the General Counsel of Twitch Interactive, a video platform and community for gamers. Boo has been instrumental to Twitch's strategic initiatives, including its $970 million acquisition by Amazon a few years ago. And she was previously Vice President of Legal for the gaming and media company IGN Entertainment. Sharon Tomkins is the Vice President and General Counsel of the Southern California Gas Company, which I imagine supplies the natural gas for a lot of people's homes in this area. And she is also the largest natural gas distribution utility in the United States. Prior to joining SoCalGas, she was a partner at O'Melveny & Myers, a firm we're going to hear some more about too. And she was a founding member of its energy, natural resources, and environmental practice. And then all the way across the stage is Brad Butwin, who is the chair of O'Melveny & Myers. And that's a worldwide law firm, as everyone knows, that consistently ranks in the top 10 of the American Lawyers A list of well-rounded law firms and was recently rated by Vault as the best law firm to work for. Brad is also, of course, highly recognized as a highly accomplished and successful commercial litigator, one of the country's top litigators. So thank you all for being here today. We're going to be talking about the state of the legal industry. That's kind of a big topic, and we probably won't cover everything about it. I know everyone will be disappointed by that, but we'll try to cover a few things. And we're going to start, I think we've got, by talking about people's careers. We've got some interesting paths here and people who are doing inside and outside legal work or have done both. And we're going to start to get a perspective on this by, I'll ask each of the panelists to briefly summarize how you ended up where you are and why it is you decided you wanted to do what you're doing. So, Boo, why don't you start us off?
Sure. So I started my legal career at Latham Watkins in Silicon Valley, practicing corporate M&A law and also some venture work, and then moved over to Perkins Coie to practice technology transactions, which set me up pretty well to go in-house, where a lot of the work ends up being commercially related. So went from there to IGN, which was a subsidiary of Fox Interactive Media. It's sort of anything related to games was encompassed by this IGN entity. So we had both gaming studios as well as media properties, as well as other services. So while at IGN, the VP of engineering approached me and said, hey, I've got this brilliant idea. We want to start an esports league in North America. And I was, despite being in the video game industry where everything was kind of focused on game sales at that point, and then reviews and things related to it, I wasn't very familiar with esports at all, which is competitive gaming at a professional level, similar to the NBA, MLB. At that point, the CEO said, hey, go run with it. I'll give you some funding, but you have to get volunteers to work on this project. So I volunteered and was one of the founding members of IPL. We later sold that to Blizzard Entertainment, and then the next day I went to Twitch Interactive. How I met the Twitch Interactive folks was through the esports. They were these young guys who had Justin TV, and they decided to take Justin TV, all of the gaming content, brand it separate from JTV, and house it under its own, within its own website, so that all of the gamers, which really does, they do compose a different community than the rest of JTV, could have a place to call their own. And so, at that point, a lot of the content that was very popular on Twitch, and it still is today, is esports content. So I was on the other side of the fence and negotiating with the founders as the content creator, or at this time, content owner, and then jumped over and helped them as their first attorney. And here we are today. A couple of years later, we sold to Amazon, and it's been 2 years since the acquisition. So I've seen both startup, where you're the individual sole attorney, putting out fires everywhere, and then also to where we are today, which I have a 16-person in-house law department. I report up to my CEO. We are separate from Amazon's law department, although we do work with them very closely.
Sharon?
So I think I'm going, can everybody hear me? Am my mic on?
It doesn't sound like it's...
No. Is it all right? So I am going to blame my career on the Adjustment Bureau for any of you who have seen that movie. I never thought I was going to be an energy lawyer. I certainly didn't go to law school to be an engineer or an energy lawyer. But my path has drawn me there, and I didn't even realize until this year that the judge that I clerked for in the Sixth Circuit in Kentucky actually worked for my company, SoCalGas, as part of a deregulation efforts of the gas industry back in the 80s when he was a member of the Department of Energy. And I actually took a pretty traditional career from law school, went and joined O'Melveny & Myers after being a summer associate there, and worked my way up to partner from a first-year associate. And I started out doing securities law, general litigation, and got on my desk the opportunity to work for Sempra Energy during the energy crisis. I'd never done anything in the energy sector, but was assigned with one of the former partners of O'Melveny to help with some regulatory issues that Sempra was facing at the time. And for those who don't know, SoCalGas's parent company is Sempra Energy. I worked on that, really enjoyed the area because there's a lot of policy, politics, and regulatory work associated with a utility or an energy company. And lo and behold, a few years later and working for Edison and expanding my practice in the energy sector as well as teaching at UCLA for a year on a course involving climate change, I decided it was time to find something else to do. And I really enjoyed working in-house. I had been seconded for a year to Southern California Edison. I liked working for a utility, and I started to pass my resume along, and somebody that I'd worked for at Sempra decided that it made sense to bring me in as an assistant general counsel over the regulatory group. I spent about 4 years doing that job. The former general counsel of both utility, SoCalGas and SDG&E, who are sister utilities, blames me for the fact that the gas utility business went from a sleepy one to a much more active environment since I came in 2010, which is, for those of you who might remember, San Bruno explosion occurred in 2010. And so I delved really deep, really fast into the pipeline industry and the regulations that we have. 2 years ago, I was promoted to general counsel and have had quite a busy year. I think all of you probably recognized that SoCalGas has been in the news a lot this past year as a result of one of our storage fields.
She was really great at the firm, too, and we miss Sharon. So I'm a securities litigator. I've been representing financial services companies in securities litigation for 31 years. Also now the chair of O'Melveny. We're now in our 131st year. So how did I get here? It wasn't really a direct path. I was slotted to go into a third-generation family insurance brokerage business. And my selection of colleges really focused on, the few that had leading insurance practices. That led me to University of Wisconsin in Madison, and basically took a lot of insurance and finance and accounting classes. Also took a constitutional law class, which interested me a lot. And then, I had this moment of truth when I graduated Wisconsin, namely, do I continue the more conventional path into the family business and, be on the golf course at 5 o'clock every day, or do I do something different? I chose to do something different for many reasons, which I won't bore you with, but one of them is that I just didn't want to be a partner with my nerd-do-well cousin. Won't name his name here on the bright lights, but decided to go to law school. Really enjoyed it and all of that. When I left law school, I clerked for a federal judge, David N. Edelstein, who was appointed by Harry Truman. I don't know how many people today can say they clerked for a judge that actually knew Harry Truman. Judge Edelstein was on the bench for 48 years, taught me a lot. Left there to go to Davis Polk, a large corporate law firm in New York. Years later, joined a mid-sized New York firm, wanted to do a more entrepreneurial thing, joined O'Sullivan, Grave, and Carabell, which merged with O'Melveny 15 years ago. At O'Melveny, again, I was a securities litigator. I ran the litigation department for a while. I became the chair 5.5 years ago. I'll be starting another term in January. I'll sort of start off maybe by saying that I'm very bullish on the profession, and I've got a lot of skin in the game. I mean, I talk to people who say, wow, I don't know if would you recommend that your kid goes to the law school? And I know John was, asked about that. And by the way, she was in our summer program, and I think she would say she got a lot out of it, but put that to the side. She picked the right firm, I would say. But 3 of my 4 children are either in law school or applying to law school. So, I'm very all in on this law thing and the future of the legal industry. And so we can get into that whenever you like.
So why don't we actually, let's start there, because you're at a firm you run a firm that has a long and distinguished history. But we've been living in times as lawyers where there's been a lot of change in the way that clients and their lawyers and their clients interact, and what clients expect from law firms. And you've spoken in the past about some of the changes that have happened at your firm and some of the initiatives you've undertaken to try to be responsive to what you're hearing from your clients. Could you tell us about some of those and how they're working out for the firm?
Sure, and I'll try not to get too granular, but fundamentally, I think the reset, which maybe started with the financial crisis, but I think was going to get there anyway, because I think when you've got industries that have some inefficiencies, something comes along and kind of helps you wring those out. So we had the financial crisis, which caused some disruption, and now we're continuing. But fundamentally, I think the changes are healthy. We should be endeavoring to have real partnerships with our clients. It's not enough these days just to be a really good lawyer, really smart lawyer. We need to be a business partner. We need to understand our clients' businesses and goals as well as they do, and to be able to deliver real value. Instead of just fielding assignments, proactively letting them know what we're seeing for other clients, even if we're not charging them for that advice, helping them look around corners, presenting flexible fee arrangements that are fair to both sides. So, Mike, years ago, and this was even before the crisis, we did a number of things to re-engineer our systems and our processes. And I think there are different schools of thought, by the way. I meet with law firm heads a lot, and there'll be some that think this is a blip or a passing phase, or we'll give a 10% discount and move on. But if you believe that things have changed and that there's a fundamental reset, as I do, then you're going to change the way you do things, and you're going to come up with ways to deliver more for less. So we started with our systems. We completely ripped them apart. We invested a lot of money in what's now state-of-the-art information systems. You read a lot about disruptive innovation and machine learning. Well, we were doing machine learning 10 years ago. So you walk into your office now. You've got your desktop, and on your desktop is every matter that you're working on with a link, with all the precedents, with all the court rules, with access to any email on a Google type search, or an Amazon type search that you can do and immediately gain access to that. And more importantly, to get real-time financial information to tell you how you're doing against your budget. We do a lot with fixed fees these days. I'm a believer in fixed fees. I'd like to do more. You know, if you ask a builder how much is it going to cost to build your house, you don't accept an answer that it's the product of however many hours we work and these billable rates. And so, you know, we don't have to wait 30 days anymore to get a pre-bill to be shocked to realize that, you know, we're spending way more time. I won't bore you with sort of the systems. A couple of other quick things internally that we did. We did a study of our writing. And, you know, we write a lot, you know, and particularly in the litigation side, briefs and memos. You know, you've got systems, you've got document review, and you've got writing. That's where a lot of your cost is. We did a study and realized that most of the spend in memos and briefs was in the middle person, you know. And if I'm a client, and I know you share this, you don't really like seeing bills that say from a, you know, first-year associate, draft brief, draft brief, draft brief, and then a mid-level, edit brief, edit brief, edit brief, and then the senior partner says edit brief, maybe it means rewrite, you know, rewrote the brief. So, you know, and we determined that about a third of the cost was being spent during this middle person editing. So what did we do? During the financial crisis, there were some pretty good Pulitzer Prize winning journalists available. They don't know a lot about stare decisis, but they know a lot about declarative sentences and muscular prose and transitions. And we hired one as a pilot program, and he edits the briefs, costs a fraction of what, you know, associates do. And then finally, just on the innovation kind of internal processy side, document review. We collaborated with an outstanding outfit that has a lot of Harvard linguists that design algorithms to really cut down the amount of time in doing these searches. And so, you know, a lot of it is investing in your systems and your processes with a goal of being able to enter into agreements that allow you to cost things in a way that are less expensive for the client but profitable for the firm.
Boo, let me turn to you about, you know, you run an in-house legal department in a disruptive, growing company, digital world, that, you know, is doing things that are probably somewhat different than the way things have been done in the past. So you're one of these clients, I imagine. You're not just running a place, but you're one of these clients who's probably concerned about the sort of things that Brad's talking about. How is it that being in the kind of company you're in and the kind of industry you're in affects the way that you manage your own department and the way that you deal with outside counsel? Sure.
So the answer kind of depends on pre-acquisition versus post-acquisition. So prior to being acquired, I came to a company that had 50 people, and they relied on one law firm, as is very common, of entrepreneurs who are very focused on getting their product to market, and they want one firm that sort of, it's a one-stop shop. If they have a question, the relationship attorney will then reach out and connect them with the appropriate specialist. It's not uncommon. So when I came on board, that model still worked to a degree. You know, certainly you don't just go to one firm when you understand that there is an individual, and I don't look to the firm, I look to the individual who has expertise in an area that, you know, that the firm that we otherwise would go to doesn't have. So, you know, fast forward to post-acquisition, as I'm building out both my own team, I select individuals based on, you know, I try to complement their skill set with whoever else and balance it with the skill sets of the other individuals on the team. So I am not a litigator. My first hire was a litigator. I have both a commercial entertainment side. We are a media company. Content is very important. I also have a strong product side because we also, of course, are a technology, probably first and foremost, a technology company. And we also, in working with outside counsel, I work with many different outside counsel on many different topics. different firms, different individuals. So yes, we are no longer bound to the one firm, one-stop shop model, of course. And in fact, I would say as the product differentiates, as we localize, as we go to more countries, we have to work with outside counsel not only on a per territory basis, but then, we look to obviously whatever the issue is at hand. In terms of disruption, so what do I do if we're working on a product or a service where there isn't any expertise anywhere in the world? Esports is a great example of that. When we first got started in esports, pre-Twitch, the model was, hey, let's throw a big event. It's really just a tournament, and you come, you perform, and it's almost like contest law, very simple, nothing complicated. Well, what happens when you want to build leagues, esports leagues? Does that translate? Do we follow the Major League Soccer model where the players are employees? Do we follow a model of golf where they're independent contractors? Do the teams hire the players? And thinking through all these complicated issues, you also have IP issues with the game publishers who own the IP. Of course, oftentimes we are just acting in a support role. These leagues are theirs, or in fact, we've seen leagues being formed by teams. A lot of this is game dependent. I think in choosing outside counsel and how to advise, the answer it depends on the game within esports. One game type, the game mechanics mirror golf. They work, it's player on player. If you have team-based mechanics, well, perhaps you look to the NFL model. So, it really does depend. And the expert that I will look to would have experience in that particular field. There aren't as many. It gets very, very specific very, very quickly.
So both more specialized, in some ways both more specialized and also more scattered.
Yes, exactly. And it will never be exactly on point. So you look for experience that can easily translate to what you're looking to accomplish.
Well, Sharon, you're at the forefront of decision-making for a highly scrutinized, very public, highly regulated utility that affects a lot of people and gets a lot of attention. What do you tell the executives in your company, without, of course, giving up any privileged information, but what do you tell the executives in your company that you and they need in order to have an effective legal department, and you and they need an outside counsel?
So I think in some ways what's old is new again, which is what I'm really looking for and what our CEO and our Chief Operating Officer is looking for is really a trusted advisor. And it's interesting, before I left O'Melveny, there was a Kellogg school program that all the partners went through, and we talked about what does it mean to be a trusted advisor. And I probably have a better answer for that now, both as a lawyer in-house who is viewed as a trusted advisor, as well as what it is I really need when I'm hiring and engaging in outside counsel. And it may be specific to the utility or energy sector where you are highly regulated, where your footprint is never going to change in the sense of you're not going to be able to get up and move the business. We have over 100,000 miles of distribution line in Southern California. It'd be really hard and expensive to move it somewhere else, and you guys wouldn't have hot water. So what you have to do, and what I have to do, and what is expected of me, and I think is more and more expected of general counsel, is that we look at the legal problem, but we also understand the business drivers, as well as the overall political and regulatory environment, and come up with the best solution. The litigation solution, if in your litigation, is not necessarily the right answer. The right answer falls into a sweet spot that mitigates the various different risks. So what do I need to do as a company to move the business forward? What do I need to demonstrate to my regulators, to the stakeholders, to the politicians, that what we're doing is the right thing? And what do I do if I am in litigation and facing a lot of lawsuits, which is what the company is facing right now, to mitigate the risks associated with that litigation? And I can tell you, it's very hard to find outside counsel who can think about all three of those areas. They have to understand the business. They have to understand more than just the legal avenue, because I'm being asked for, my CEO, my chief operating officer are asking me, what do you think? What do you think is the right path forward? Not what's the legal path forward, but what's the right path forward? And we'll have a discussion. I think it's also really important, at least in the culture of my company, is we're really a part of a team. We have a lot of smart people. We have a lot of people with a lot of experience. And really, we're engaged as a team. It's not the lawyers off doing their own thing and then asking, this is what we need to do. It's really collectively getting the wisdom of the engineers, getting the wisdom of our regulatory affairs people, getting the wisdom of both in-house and outside lawyers, and figuring out what is the best solution. How do we move the company forward? And I think that comes back to really what is the definition of a trusted advisor. Now, my trusted advisor and outside counsel has to have certain areas of specialty. I'm not gonna hire a transactional lawyer to help me out with litigation. But I do expect that the lawyer will be thinking beyond just the litigation or beyond just that one matter and trying to understand and asking the right questions. I don't expect somebody to know everything. My CEO or the chief operating officer don't expect me to know everything, but they expect me to ask the smart questions. They expect me to be engaged and to try to understand and try to figure out what the solution is. So, I go back to what is old is new again.
Yeah, I have actually a question for Sharon on that point of trusted advisor. We were actually at the same Kellogg class. This was like 10 years ago. And there was a class on innovation, interestingly enough. And everybody was in the room saying, listen, the firms do the same thing. All the firms do the same thing. And if you have a good year, you're up 20%. If you have a bad year, you're up 8%. And, you try to get more leverage. And if you raise rates, you raise rates. And the professor basically said, showed us 8 different industries where that was the thought. It was a follow the leader industry, and the whole industry kind of went away. The Polaroid, Kodak, situation. And he kind of put on his screen. He said, I'll tell you what keeps me up at night. He said, my colleagues, my professors care most about that we're ranked 3rd behind Harvard and Wharton. He says, what scares me is, and he posted, Phoenix University, like this new online thing. But so anyway, that professor sort of called everything that was about to happen 2 years in advance. But on the trusted advisor point, is a trusted advisor, is it a firm or is it a person? And the reason I ask is because many, many years ago, I used to hear a lot of about, sort of what Boo was saying, putting together a virtual law firm. I'm going to pick, a lot of different law firms. In your case, you don't have a lot of experts who really know it, but, philosophically, we used to hear a lot about, we're just going to put together the all-stars from many, many different firms. These days, post-crisis, we hear a lot more about convergence. We're going to take our 800 firms or 100 firms and skinny them down to 20 because we want dedicated, efficient teams. And in return, of course, we're going to ask for, cost concessions because we're going to be, providing more business to a smaller, segment, if you will. So, in your, I'm not trying to take your job away, but
yeah, I was going to ask this question. So
I'm curious. Are you more in the convergence school, which is I want to have a handful, whatever it is, trusted advisor firms, or for each matter, are you kind of looking at individual expertise across a much, much broader set of firms?
So I'll take it in 2 stabs. One, we have what we call the community of counsel, which is about 25 law firms that really do our go-to business. We created the list by asking all of the lawyers, what kind of work do we go to outside counsel for? And who do you like to work for? And this came up with a list of 25 different law firms, more or less. And they are our primary providers. That list, though, isn't stagnant. And each year, we've started an evaluation process to really look, do we have that right suite of lawyers that do our core business? Now, there's going to be times where you need a different area of specialty, and you will go out to do that. So as a general answer, we have reduced, in an effort to reduce our overall spend, and this is on the Sempra-wide as opposed to SoCalGas specific outside counsel spend, to get better efficiencies, to be able, so that they understand our business when we go to them. We have, so we've done that, and I think it's been effective. Whether we have the right mix of lawyers yet, I don't know, and I think that's an ongoing debate. I think it's also sometimes, and you know, Elise is probably the biggest litigation, the biggest legal thing that's happened to the gas company in its 140 plus years. And what we were looking for has changed a lot, and we did engage a number of law firms to help us out. And there, we're really asking for them as a group to work and coordinate it to provide the most efficient and effective advice for us in that particular set of proceedings where we're facing regulatory issues, we're facing litigation, we've had legislation that that's been specifically drafted for us. So it's been one of those things that we've really sort of created a mini community of counsel. I don't know that it's perfect yet. We're, you know, and as things change, the dynamics changes to what we're facing, and so we can modify that. But it still fundamentally goes back to, do I feel, and my client, and my client, the company, the operators, feel that we're getting good service? And because I have CEOs and COOs and vice presidents who roll up their sleeves, we were in a 3-hour meeting working through a letter yesterday where, you know, the chief operating officer and a number of vice presidents were there. We were redlining with the lawyers, and it's really that process. And so they too will make comments about what they think of the outside counsel, and that matters.
Well, let me follow up with you, because your answer earlier, I think partially based on the relatively brief history of your industry, would seem to imply that there's really no way right now you could have, say, a firm that was, you know, your trusted advisor that you went to for 80% of your work or 75% of your work. Is the situation you're in, where you have to go to a lot of different places, the one you'd like to be in? Or would you prefer to have the legal industry move in a direction where it's easier for you to put the bulk of your work in one or two places?
So I think I said two things. So pre-acquisition, we did, and when we were small and our product was not as differentiated, we didn't have multiple product lines and services. We certainly wanted, in fact, when you're thinking about an exit, you want one firm that knows your company inside and out, so that the clients can focus on what they need to, which is the product and building their, you know, in our case, user base. And so that was very powerful and effective in actually going through a sale. We knew our outside counsel knew us inside and out, not just our corporate lawyers who sat on our board in all of our board meetings, but then also the M&A counsel, the commercial counsel. So at that time, it meant a lot to have a trusted advisor that included a few attorneys within that firm, as opposed to the situation where we are now, which is actually not unlike the situation it sounds like, Sharon, you guys are in. We do have Amazon's preferred provider program. So we do have a smaller group of firms that we work with. Twitch still does. We are a subsidiary of Amazon, and in fact, work within their program that they help us negotiate better rates. But you know, that being said, if there is a disruptive type technology or service where the expertise may not lie within that preferred provider program, I certainly would be able to go get, use whichever firm and whichever attorney made the most sense for that situation. Yeah, and you know, a preferred provider program, when you're global and looking at issues territorially, you may not have, that attorney may not be covered because it is a specific issue that just came up in Luxembourg or Germany, you know, so I think it really is a hybrid model.
Well, you sort of started us off on this path, Brad, and I'm wondering about your reaction to this, the answers we're hearing now, as somebody who's running a law firm that obviously would probably like to get as much business from your clients as you can.
Yeah, no, it makes perfect sense, and one size doesn't fit all, you know, and you know, there are you know, many different types of clients in different sectors. So if you look at, you know, the pharmaceutical companies and the financial services companies, like that industry has very much gone to a convergence model. Often it's because there are a lot of acquisitions, and you know, at some point, you know, you've inherited 700 law firms. So you know, you've certainly got that pretty large pool, and you know, for us, you know, we want to be doing work for companies that are repeat consumers of legal, you know, who consistently, you know, spend on legal work and do it across geographies, and you know, where we are a good fit. And you know, there are those that have the view, and this is sort of an older view, that you know, there are firms that just want to do, you know, the top 2 or 3% of a company's work, the so-called bet your company work. And that's the way I think a lot of firms were years ago, right? We're this firm or that firm, and you know, for this other type of work, you know, you can use other firms, but for this type, you know, this is our sweet spot. These days, you know, our view is, you know, we don't want to be telling large consumers of spend that we don't really want this work. You know, we only want this work, assuming we can do, you know, both types of work well. And so it's on us to figure out how to do the work that, you know, historically wouldn't have gone to a major firm. It could be that we're willing to do it as, you know, for free, I mean, or at cost, as a pass-through. You know, it's not a good business model to have clients, to basically tell clients, you know, take as much work as you want in-house, that's fine, or go to this document vendor because they'll review the documents less expensively, or go to Axiom for your legal research because, you know, there are former associates anyway. I mean, at some point you've got to make a decision whether, you know, you want to be a trusted advisor. And I don't think, I would guess it doesn't sit particularly well with clients where when they call you up and you say, you know, this isn't really, you know, work for us. So I'm seeing a lot of convergence in various sectors. But, you know, we also want to be, you know, considered for the most interesting matters. You know, we are fundamentally, not fundamentally, but we are, you know, one of the few firms, you know, John's is another, Paul Weiss is another, that has more than 50% of its lawyers, you know, in litigation. And so, you know, we still want to be in play for, you know, the biggest litigation, whether it's the next product recall, the next oil spill, you know, even if it's not for an incumbent client. So I guess I'm saying, you know, we'd like to have it always, but the way to do that is to be, you know, very client-friendly and understand what they need and what they want.
I'm just going to sort of echo off what Brad said a little bit, which is when the, you know, crisis hits, when you all of a sudden really need to up your game with respect to the outside counsel, you're probably going to look first, do I have somebody that I already trust who can do this? So I think it's actually a good and smart to not just say, I'm the company, I'm here, I save the day, because it's probably who is on, and I'm going to use Rolodex as a really old term, but nevertheless, who is on my Rolodex that I can call that can help me out, because I really need it now. And if you don't have that, then you really are looking for reputation. And reputation, is everything for the lawyer. I remember John Dahm, a former partner of mine, said that whenever you go into the courtroom or you go somewhere as a lawyer, your reputation is everything, and you can blow that in a minute. And you also are representing the firm. And I think that really matters. It's not the sales pitch, the glossy document that we get is nice, but it's not what I'm looking for. And if I'm looking for somebody because I don't have somebody on my Rolodex, I am going to be asking people who they would use, who is best in this space. And it's going to be word of mouth, it's going to be reputation that I'm going to be looking for. And I probably won't be going through, and this assumes I save all the glossy binders.
Or read them.
Or well, yeah, I certainly don't save them, and I'll just plead the fifth on the second question. But in any event, I'm really looking for who is somebody that I can go to that's really going to be able to help me, and that's reputation.
Well, I'm afraid we're out of time. I'd like to keep the conversation going, but we have to move along. But I want to thank Brad, Sharon, and Boo for a really interesting conversation. Thank you very much.
Thank you.
Thank you.
Thanks so much, Sharon.
Thank you, Mike, and to the panel. That was a very informative conversation. We really appreciate it. And since we've had two key litigators, we thought an important part of this conversation really should be about litigation management and the business of litigation in the profession. So it is my pleasure to introduce to you Whitney Joines-Roy, who is the managing partner of Shepherd Mullen, and she's going to lead a conversation about the business of litigation management.